Welcome to the C.I.A. Services Associations and Practice series of videos. Today we will review the 88th session of the Texas Legislature and its impact on property owners associations. My name is Ralph Troiano and I'm pleased to provide this recap. Let's go ahead and start with how laws are made in Texas. Well, every 2 years the Texas Legislature meets for 140 days. The first session was way back in 1846, just a few months after Texas became a state. This session, the 88th regular session, began on January 10th and ended just a few days ago on May 29th. There were over 11,000 bills introduced in this session, with about 150 having potential impact on property owners associations. Now, typically half of the bills introduced make it into law, just 38% in our last session in 2021. But when this regular session ended on May 29th, Governor Abbott immediately called a special session to focus on property tax relief and human trafficking. He'll probably be calling some additional sessions for some of his priorities. However, it's unlikely anything related to POAs will be included. The 88th session had its normal shares of bills aimed at POAs, so let's review. Let's go ahead and start, though, with what did not pass. There were several bills which raised concerns in the industry because of the phrasing of the bills or other things. One was what we call the chicken bills. There were a whole series of those that were filed in this particular session, and House Bill 92 we thought was actually going to pass. Surprisingly, neither House Bill 92 or others passed, even though there seemed to be support in both houses. In the chicken bills, it's basically so owners could have up to 6 rabbits or chickens for their own consumption, the eggs and the meat. It also included some provisions for gardens at properties. A good bill, but it did not pass. Cottage food production, there were 2 bills here that would allow owners to produce food in a cottage food production operation. You had to read the laws to figure out what that meant, but it basically meant people could create, grow, cook, produce food at their property, and then sell it at their property or away from their property. One of the 2 bills stalled in the Senate, the other one stalled in the House, did not pass. One that was of significant concern was House Bill 1367. It didn't pass. It would allow any owner to file a lawsuit in JP Court for any perceived violation of the association's governing documents or the Texas Property Code. Because of the way it was phrased, it would have a very chilling effect on volunteerism because of the liability that would be placed on volunteers. Fortunately, it did not pass. Then we had House Bill 1252 about financial audits. It would have required an audit every year with a copy then sent to every member. Audits are good, there's no doubt about that. This would have added significant expense, and associations don't necessarily need audits. The Financial Controls Association are with a good management company and day-to-day oversight by the volunteers, the board members. That provides the best assurance that things are being handled properly in the association. Others that didn't pass, there were 2 that had to do with amendments to the declaration, the CC&Rs, the deed restrictions. First of all, House Bill 2428 had some strange language in there. In most associations, you get 1 vote for every property you own. So if you own 2 properties, you get 2 votes, 3 properties, 3 votes. But this one didn't talk about the lots or the properties you owned. It talked about the owners. And it used those terms interchangeably. So apparently, if it did pass, it meant that a husband and wife who owned 1 lot, 1 property, would get 2 votes. But the widow next door would only get 1 vote. If there were 3 owners of a property, they'd get 3 votes for their one lot. So fortunately that didn't pass. The language was a little jumbled in that one. And then House Bill 1786, this one had a good intent, but it was just written very poorly. It indicated that any proposed amendment to the dedicatory instruments, I'll define that in a second, needed to be mailed to each owner by certified mail, which would be very expensive, and allow the owner to vote. That makes sense. If you want to amend your deed restrictions, you certainly need to make sure everyone's aware of it. The problem is a dedicatory instrument is any governing document for the association, including pool rules. So it wouldn't make sense that you'd have to, just to change the pool rules, you'd have to send something out to all the owners by certified mail and give them the opportunity to vote. The ability to amend pool rules lies within the board, not the owners. Then we had House Bill 330. That would have allowed, would have required a POA to allow wind power facilities of an appropriate residential scale. Really, really vague. I'm sure we don't want wind farms in a community like we have in West Texas, but it just was not clear exactly what it was trying to do. Finally, Senate Bill 468, Right of Assembly. This would have required a POA to make its common areas available without restriction for gatherings of the general public for any peaceful purpose. Sounds great. It specifically mentioned so that political candidates would be able to come to communities and speak. The problem is that it said any common areas must be available, period. And so, for example, if someone wanted to have a gathering of their club and they wanted to do it on the pool deck in the middle of winter when the pool is closed and there aren't any lifeguards there, this would have allowed that. If someone wanted to use the clubhouse and the association normally has a registration that you have to fill out in advance to schedule it, and you need to pay a fee to use the clubhouse, this would have said, no, you don't have to register, and no, you don't have to pay the fee. So the way it was worded was problematic. Fortunately, it did not pass. Well, let's go into the things that did pass. First of all, there was some cleanup from the last legislative session. There were a couple bills that passed which had some vagueness or problematic language, and we really appreciate that the Senate went ahead and introduced a bill that was then passed by both houses. From the last session, in Chapter 209, that prevented a board member's spouse, or anyone from that board member's household from serving on the ACC. That was problematic simply because we have situations where there just aren't enough volunteers to staff both the board and separate volunteers to staff the ACC. And so one of the things that was cleaned up is that's still the requirement. However, if you cannot fill the positions on the ACC using that eligibility criteria, there is now a procedure where you can solicit volunteers, and eventually the board can appoint folks to the ACC, including board members, spouses of board members, or members of that household, if no other eligible volunteers are available. And finally, in Chapter 202 of the Texas Property Code, there is the provision that allows an owner to install a fence and call it a security device. In the last session, they simply had that right without any restrictions. Now there's some reasonable limits on the placement of the fence, the location of the fence, what it covers up, if it blocks any views, because it can be in front of the property, if it blocks sidewalks, if it presents a hazard at driveways and things of that sort. So those cleanups were really good. One of the bills that was of most concern in this session was House Bill 886. However, it did pass, but it was improved before passing. Originally, it would have added a 7-month delay and quite a bit of additional cost to a typical delinquent collections process, the steps we go through if an owner does not pay their assessments, get on a payment plan, or provide some sort of a reason that they're not able to pay. The version that passed does add a 2-month delay to the process, but there are no additional costs over what we normally do in delinquent collections. So here's the new cycle for annual assessments. Monthly, quarterly, semi-annual are similar, but the annual is easiest to just review the dates. So typically the initial statements go out no later than the end of November for the next year's assessments. And the assessments are due by January 1st, overdue 30 days later. So a first notice of delinquency goes out by regular mail, a past due notice, in February. If the owner still does not set up a payment plan, make a payment, or contact the association, we send a second notice of delinquency by certified mail. It has some specific language required by the Texas Property Code, and that goes out in March. Previously, we would then, approximately or at least 33 days later, file a lien. That was done in April. Now the law says there needs to be a 90-day period between when you send that certified letter and when you can first file a lien. So that'll push back the lien to the April timeframe to the June timeframe. That's the 2-month delay. If the lien is delayed, also sending it to the attorney, if necessary, is delayed. Previously, that was as early as June. Now it's early as August, so we wouldn't get to an attorney until 8 months after the assessment was due, 8 months or more. We will need to change collection policies to reflect the new law. The next change in law is fines. And basically that says that if association has a right to fine under its declaration, and many and maybe most property owner associations do not have this right, but if they do have the right and they do want to fine owners, then the POA must adopt a fining policy. That sure makes sense. The policy must specify what offenses are finable and what the dollar amounts of those fines would be. That policy must be recorded in the public records and posted on the POA website like all other dedicatory instruments. Any POA that fines should already have this policy in place, so this law should not impact associations, and if an association doesn't have a fining policy and is fining, well, shame on that association. Now it's the law, they must. Then we have one small one, and I only point this out because it's what we refer to as a bracketed bill or a highly bracketed bill. A bracketed bill is one that doesn't apply statewide. It applies in a geographical region. In this particular case, House Bill 1558 applies only to subdivisions in the city of Houston and within that geographical region, only ones which were platted before 1947. The reason for that is that some of those subdivisions had restrictions, but they were restrictions that would expire, or they just weren't suited for where we are 80 years later, almost 70 some years later. This bill provides a mechanism for those subdivisions to update and extend their deed restrictions through a voting procedure of the people who live in those subdivisions. It adds Chapter 216 to the Property Code. This type of highly bracketed bill is not unusual. Several of the chapters of the Property Code were written for the same purpose of helping some associations related to their governing documents. The last thing I want to point out is something that doesn't directly affect POAs from the standpoint of the POAs are not mentioned in the legislation, but it may impact our ability to seek assistance from cities or counties on issues within our communities. Basically, what the law says, it prohibits any local jurisdiction, so that would be a city or a county, for example, from creating ordinances, orders, or rules unless the state expressly gives them that right. So effective September 23rd, any such ordinance, orders, or rules is void. And it covers all these areas of the codes of Texas. And so what are some examples of this? Well, for example, in the Houston area, both Harris County and Houston during the pandemic issued orders relating to wearing masks, sanitation, protection, operation of businesses, and things of that sort. In the San Antonio area, there have been attempts to require mandated sick days for employees. One is a labor issue, another one is a business and commerce issue. And so those abilities to create orders or ordinances or rules are being restricted by the state effective September 1st. So in summary, we had a normal flurry of bills, almost 12,000 total bills and about 150 that concerned POAs, but only a few passed, with none having any significant negative impact. Those that did pass mostly stalled due to other legislative priorities, and so we'll see them come back in 2025. Until then, let's continue to provide outstanding services to our clients and all of the great residents in our communities. Thanks for joining us here.